News broke yesterday that Utah Senate President Stuart Adams sent cease and desist letters to 4 people demanding that they retract some things they said about him leading up to this year's primary election. Those letters were in response to some of the comments that were made about his granddaughter's criminal case, campaign finance, the Stratos data center project, and a controversy over office space in the Utah State Capitol. Essentially, he's threatening to sue them. So I dug into these letters a little bit and looked at Utah law to see if Adams might actually have a case here. Now, Adams is one of the most powerful members of the Utah legislature, but he lost this year's Republican primary to Stephanie Hollist. And because of that, Adams has to leave office when the Utah legislature convenes in January. The letters from his lawyer were sent to Utah State Auditor Tina Cannon, a political consultant, Gabrielle Finlayson, and the hosts of a far-right podcast. Here's some background on what those people said. The first comments were about his granddaughter's criminal case. In 2023, Adams' step-granddaughter, who was 18 at the time, was charged with 2 counts of rape of a child and 2 counts of sodomy on a child. And those are all felonies here in Utah, first-degree felonies. And that was after she had sex with a 13-year-old boy. And in Utah, anyone under 14 cannot legally consent, so he was a child, and she was facing years in prison and having to register as a sex offender. Now, at the time, Utah law allowed 17-year-olds to be charged as juveniles with unlawful sexual activity, which is just a 3rd-degree felony. So his granddaughter was charged in 2023. During the 2024 legislative session, Adams backed a change that allowed prosecutors in Utah, in some limited cases, to treat 18-year-olds accused of child rape as minors if they were still enrolled in high school, which allowed prosecutors to give them a lesser charge instead of the 1st-degree felony. Adams' granddaughter just so happened to fit those circumstances. The change in the law was retroactive, so it wouldn't have applied to Adams' granddaughter. But the change in that law is one of the reasons cited by the judge in the case, the prosecutor, and the defense attorney. They cited that that was a big reason why she was offered a plea deal. She pled guilty to a 2nd-degree felony. The law change said a 3rd-degree felony. She pled guilty to a 2nd-degree felony, and the change in the law was one of the reasons why they offered her a plea deal. Adams says, he's had nothing to do with the law change, and it would have applied in the first place. On the campaign finance front, in 2024, several complaints were filed against Adams with the Utah Lieutenant Governor's office over his campaign finance disclosures for his campaign and for 2 political action committees he controls. Now, for years, Adams reported hundreds of thousands of dollars in campaign expenditures. But when he went to list what those expenditures were, he just listed payments to credit card companies like American Express or Visa or MasterCard or whatever. And Utah law specifically says you cannot do that. It says that you have to disclose the ultimate recipient of that money. You can't just say you paid a credit card. You have to say what you were paying off. And Adams hadn't done that for years. So he was technically violating Utah law. Well, the Lieutenant Governor's office investigated the whole thing, and they said that what Adams was doing with his reports was not allowed. But they also said that he was given conflicting information from the Lieutenant Governor's office after they were looking into those things or those complaints were filed, so they weren't going to impose any sanctions against him, and he wasn't really guilty of campaign finance violations, even though the Lieutenant Governor's office said what you're doing is not allowed. It was against Utah law. He broke Utah campaign finance law by what he was doing, but he didn't get punished for it. The controversy over the space in the Utah Capitol building comes out of his years-long feud with Utah State Auditor Tina Cannon. She's clashed repeatedly with Adams, and she went on that far-right podcast to discuss the efforts that Adams took to kick her out of that space in the Capitol. Now, on that podcast, she said that Adams controls the board that allocates space in the Capitol. That's not true. He's not the chair of it. But she also said that he bullied some senators and promised others space in her former office if they went along with him on this. And we all know the data center issue, the Stratos data center up in Box Elder County, the hyperscale data center. Adams is the chair of MIDA, which is the Military Installation Development Authority. And that group greenlit this massive proposed data center in Box Elder County and then helped push it through with the Box Elder County Commission. And actually, two of the Republican commissioners in Box Elder County lost their reelection bid. They were ousted mostly as a result of this whole data center issue. And the backlash from that project is the most likely reason that Adams lost his reelection bid. So this week, Adams sent out these letters demanding a retraction. They were cease and desist letters demanding a retraction from these people and an apology over these statements. And it sure sounds like he might file a lawsuit against them if they don't comply. He issued a statement. He said this on Facebook: "All I want is for the lies to stop. For months, false statements have been repeatedly spread about me, despite the facts and the public record, showing a reckless disregard for the truth with the intent of damaging my reputation and causing tremendous harm to my family." So Adams is threatening to sue. So what does Utah law say, and how likely would he be to file a lawsuit over these statements that he said are false? I'm not a lawyer, but I did do some digging, and here's what we know. These letters do identify some real factual errors in these statements. Adams' granddaughter did plead guilty to a second-degree felony, but the change in the law that he was behind, he says he wasn't involved in those discussions, but he did discuss this change in the law with the bill's sponsor. The change in the law would not have applied retroactively to his granddaughter's case. It was passed in 2024, and she was charged in 2023. So that is a bit of a factual error. Adams is not the chair of the Capitol Preservation Board, which decides space in the Utah Capitol. It's the governor and other legislative leaders who are in charge of that. So that is also a factual error. But a factual error alone doesn't automatically make a statement defamatory. If you say something wrong, it doesn't automatically mean that this is defamation. Adams is one of Utah's highest-ranking elected officials, and to win a defamation case, he would have to show that the speakers made false factual claims with actual malice. That's the term used, actual malice. That they knew that the claim was false or seriously doubted it at the time. Just saying that they should have known better is not enough to prove a defamation case. And he's got another problem. In 2023, Utah expanded their anti-SLAPP law. Now, an anti-SLAPP law is used to crack down on frivolous lawsuits that are meant to cause people to have to spend a whole bunch of money and time defending against these lawsuits. Well, Utah expanded it, and the law is called the Uniform Public Expression Protection Act, or UPEPA. And that law, which Adams voted for, would probably cover a lot of these statements because it concerns public officials, public policy, legislative action, and government decision-making. It allows for people to make these statements or make statements like this in public, and it sets the bar for proving that it was defamatory even higher. The legislature passed this law in 2023, and it was part of the whole anti-woke, anti-cancel culture thing that was sweeping the nation at the time. And this is just to prevent people from being sued, from being hauled into court for things that they might have said that would offend someone else. And Adams did vote for this law. So theoretically, if Adams were to move forward and file a lawsuit, remember, these are just cease and desist orders. They're essentially threatening a lawsuit, but he hasn't filed one yet. If Adams did move forward to file a lawsuit, the defendants under this law, UP-EPA, could file a fast-track motion to dismiss this within 60 days. And at that point, the lawsuit essentially pauses while the court decides whether Adams has enough evidence to support every requirement of a defamation case. And if Adams can't prove that at this early stage, if he cannot show that evidence, the court would dismiss the case, and Adams could be ordered to pay the defendant's attorney's fees and litigation costs related to that motion. So there's a real risk here for Adams if he were to move forward on these claims, because remember, we said before that just because you state something wrong, just because you say something wrongly, that does not mean defamation. He would have to prove that they knew it was wrong when they said it, and they said it with malice, with intent to cause harm to his reputation or his business or his family or whatever. And that's a pretty high bar to cross. Adams would have to do that in the early stages of this case if any of the defendants were to make a motion under this 2023 law. Now, the weakest of Adams' claims are some that are just, seen as broad political rhetoric, that he controls a board. He doesn't control the board, but I don't know if that would qualify as defamation or actual malice. Accusing officials of keeping a project from the public. That's one of the claims about the Stratos data center, that Adams kept this out of the public eye and pushed it through without the public really knowing. And that's not true. There was a public process, but it was extremely rushed, and that's what caused a lot of the backlash. And if he were to take these people to court over these claims, there's a real risk that they could be treated as opinion, hyperbole, or criticism rather than provably false facts. Some of Adams' claims seem much stronger, especially the ones that are really specific, that Adams promised space in the state auditor's old office in exchange for support, or that he bullied senators into going along with him at a meeting. Those claims can be checked against witnesses, or if there are any recordings or any messages about them. So there could possibly be evidence that would support that. Even then, Adams just couldn't say that never happened. He would need evidence that the person who said it had no credible basis for saying it or knew that it was false. In the case of Adams' granddaughter, there's a couple of things we need to consider. Claims that the law that was passed after she was charged in 2023, the law was passed in 2024, and Adams says that change did not legally determine the granddaughter's sentence. Well, there might be records that could help resolve that, which would be the discovery portion. If he were to file a lawsuit, he would have to go through discovery, and there might be records. There could be emails or documents or whatever that would prove or disprove that claim. But Adams also objected to the claim that the timing of that change in the law looked like him wielding his political influence. And that might receive much stronger constitutional protections than the first claim, because once again, it could be treated as opinion, hyperbole, or criticism, and rather than provably false facts. The first claim, that the law change determined the outcome of his granddaughter's case, well, that could be proven as a false fact. That could be proven to be a false claim. But saying that the timing was him using his political influence, that is probably not a provably false fact. So these letters are a very forceful public statement. It's a rebuttal against those criticisms that were leveled against him in the lead up to the GOP primary, which he lost, and he's probably still stinging from that loss, and he wants to set the record straight. But under Utah's anti-SLAPP law, which they expanded in 2023, and the actual standard that he would have to meet to prove malice, that's a pretty high bar, and that's not necessarily a very strong blueprint for a successful defamation lawsuit. Remember, he would have to go through discovery on these claims. not only would the people who he would be suing for defamation have to turn over documents, but he would have to turn over documents as well. And there might be some embarrassing things in there. And you wonder if he would actually want to go through with this. But right now, everybody's talking about it. Everybody's talking about these claims and Adams pushing back against them. But if it's just him trying to get an apology through a threatened lawsuit, or whether he's actually going to move ahead with it, that remains to be seen.